We're celebrating a birthday, and it's Uncitral's 40th birthday. And who better to reflect on the journey of the Uncitral model law than Takashi Takashima, the legal officer at Uncitral, to dig deeper into fairness and predictability. Stage is yours.
Thank you for the introduction, and a big thank you to the organizers for having me. The Uncitral Secretariat is truly grateful for this opportunity to celebrate the 40th anniversary of the Uncitral Model Law on International Commercial Arbitration. We are particularly grateful for SCCA for reminding us that this year indeed is the 40th anniversary. Uncitral is a legislative body in the field of international trade law established within the UN by the UN General Assembly back in 1966. And you might think, aha, as 2026 marks the 60th anniversary of Uncitral, the 40th anniversary of the model law is at times overlooked, which we think should not be the case given its significance. The mandate of Uncitral is to promote the progressive harmonization and unification of the law of international trade. This mandate can be broken down into two. One is to develop norms and the other to promote them. As you may be well aware, the three pillars of the arbitration framework are one, the New York Convention, two, the Uncitral arbitration rules, and three, the model law on arbitration. I just mentioned them in the chronological order in which they were developed. The model law was first adopted by Uncitral on the 21st of June, 1985. It covers all aspects of the arbitral proceedings, and it is considered to be reflective of the worldwide consensus of principles and important issues of international arbitration practice. The model law is based on 6 key principles, which have been referred to in the course of discussions today. Party autonomy, obviously, limited instances of court intervention. I quote this, which is reflected in Article 5, which provides, in matters governed by this law, no court shall intervene except where so provided in this law. Competence, reflected in Article 16. Separability of arbitration clause, also reflected in the same Article 16. Setting aside provided as exclusive recourse in Article 34, and last but not least, the enforcement regime modeled on the provisions of the New York Convention, specifically Article 4 and 5. So let us now have a closer look at the history of the model law. In June 1981, the Commission entrusted the Working Group on International Contract Practices with the task of preparing a draft model law on international commercial arbitration. And in June 1985, after 4 years, based on the work carried out by the working group, the model law was adopted by the Commission. It is usual practice that the UN General Assembly adopts resolution on model laws adopted by the Commission. And in a resolution adopted in December 1985, the General Assembly expressed its conviction that the model law, together with the New York Convention and the Uncitral arbitration rules, would significantly contribute to the establishment of a unified framework for the fair and efficient settlement of disputes arising in international commercial relations, and recommended that all states give due consideration to the model law. In June 1999, the Commission entrusted Working Group 2 to prepare proposals for the improvement of arbitration laws, particularly regarding the enforceability of interim measures of protection and the requirement that an arbitration agreement be in writing. In July 2006, which is after 21 years after the adoption of the 1985 model law, the Commission adopted the legislative provisions on interim measures reflected in Chapter 4A and the form of arbitration agreements reflected in Article 7. Sorry. Again, following regular practice, the General Assembly adopted a resolution in relation to those revisions in December 2006. The General Assembly expressed its belief that the revised articles of the model law on the form of arbitration agreement and interim measures reflecting those current practices would significantly enhance the operation of the model law and recommended that all states give favorable consideration to the enactment of the revised articles of the model law. So, what is the status of the model law at present? To date, the model law has been a great success. Legislations based on the model law have been enacted in 93 states in a total of 126 jurisdictions. It's always nice to show this map. You see the different jurisdictions in colors. Now we turn to what the future looks like for the model law. At the request of the Commission, since 2021, the Secretariat has been implementing a project entitled The Stocktaking of Developments and Dispute Resolution in the Digital Economy. This is a project through which the Secretariat explores the impact on the impact of digital technologies and digital technology services on dispute resolution. And as I mentioned at the outset, because UNCITRAL is a norms developing body, the work is being carried out with a view to updating existing norms or developing new ones. And one of the key deliverables to date of this project is in relation to this question. Why do we continue to rely on paper-based awards? There are two aspects. One is perhaps a psychological aspect that practice is already heavily accustomed to the practice of relying on paper-based awards, and it would be difficult to change course unless there's a pressing need to do so. But the project has identified in its findings that the findings demonstrate that the root cause of this problem is basically the persisting legal uncertainty on the recognition and enforcement of electronic arbitral awards. So the findings have been presented to the Commission back in July 2024. Having considered the findings, the Commission decided to mandate Working Group 2 to work on the recognition and enforcement of electronic arbitral awards, and also requested the Secretariat to organize a colloquium to further assess the issues. So to date, the Working Group 2, has carried out its work in 2 sessions, one held in October 2024, which took place in Vienna, and the other which was held earlier this month in New York. At the Working Group session, which was held in October, 2 days were dedicated to holding the colloquium, in which the Secretariat invited 20 experts from around the world. And I should mention at this stage that we have had Dr. Hamed Mera as one of the 20 experts and has contributed greatly to the discussions as a panelist. And you see here that work is underway in all different levels, at the level of the New York Convention, the model law, UNCITRAL arbitration rules, and also, not that I didn't overlook this instrument, but also the notes on organizing arbitral proceedings, which is a relevant reference point for arbitration practice. So work is underway to provide legal certainty on recognition and enforcement of electronic arbitral awards. So in the near future, I think it would be a reasonable or educated guess to say that the model law may be updated in 2026. By the way, I should note that the Secretariat is not in a position to say whether, how, or when the model law should be updated, but nevertheless, an objective observation of the discussions show us to indicate this possibility. It's not that the working group is carrying out the work from scratch. In the area of electronic commerce, it has been long understood that although paper-based documents and electronic documents, they are different. Paper-based documents, they are readable by the human eye. For electronic documents, you need a screen, software, and a computer. There's a fundamental difference, but it is also understood that the electronic documents can perform the same functions of a paper-based document. And based on this understanding, in the field of electronic commerce, there have been principles and rules being developed. One is the non-discrimination rules, which stipulate that information in electronic form should not be denied validity, enforceability solely on the ground that it is in electronic form. And in order to make that happen, functional equivalence rules, which are requirements required in the electronic context so as to enable electronic information to be able to perform the same functions as the paper-based documents. So the question before the working group is to basically integrate whether and to what extent to integrate those norms that have been developed in electronic commerce is the question at the work at hand. I should also, however, note that already in 2006, this integration has happened, although very discreetly, for arbitration agreements, which requires that agreements be in writing. And so there has been an integration of this written form requirement equivalent of arbitration agreements into the model law in 2006, but no updates have happened for awards to date. So this is primarily the reason why the working group is working on this subject matter. So in the next 20 years, what to expect? I know that when I put this forward like this, it gives expectations that I might say something innovative or provocative, but to manage expectations, I will not do so. I will mention at the outset. But I do think that there is an existing provision in the model law which refers to telegrams, telecopy, telex. And I put this in question marks because if I ask my children what a telegram is, they would have no clue what they are. And maybe in 20 years' time, even more so. So I think there is a hook or something that attracts maybe people in the future to think about a further update of the model law, maybe, maybe not. And also, frequently mentioned in the discussions today is the topic of AI. I don't want to confine the subject matter just to AI, considering the rapid speed of development, but AI is something that we also have in mind in our work and is representative of the ever-changing world that we live in today. So these are some suggestive or the issues or the catalysts for maybe possible future updates of the model law. But having said that, we believe that the model law would be a solid and a very trustworthy foundation for many more years to come. And with that, I conclude my presentation. Thank you very much.